So this morning I'm here to talk about unemployment benefits for survivors of domestic violence. I feel like sometimes this is an untapped resource for survivors, and hopefully maybe we can change that. So I'm going to quickly go through my first couple of slides, which are just basic SCLS slides about our services. And since there have been many of us this morning who have already spoken, I'm sure you already know that we provide free legal services to individuals and households in South Carolina if they are under 200% of the federal poverty guidelines. However, if they are a victim of crime, which a survivor is, then of course we can go over that 200% income guideline. And we provide legal representation in a variety of different issues, as you probably have heard this morning. And this is just a quick summary of the things that we do here at Legal Services. So also, just my basic disclaimer, I'm not providing legal advice. This is for information purposes only. And if you have a specific circumstance you would like assistance with, please do not hesitate to reach out. So I'm sure you're familiar, but I will just go through the economic impact of domestic violence. Victims, survivors of intimate partner violence lose about 8 million days of paid work each year. Between 21 and 60% of victims of intimate partner violence lose their jobs for reasons related to the abuse. 142 women were murdered in their workplace by their abuser between 2003 and 2008. I should update those years. And that represents 78% of all women killed in the workplace during that time. Between 2005 and 2006, 130,000 stalking victims were asked to leave their job as a result of their victimization. And in all of, in these instances, women who lose their job as a result of intimate partner violence should get unemployment benefits while they are looking for a new employment situation. So the purpose of unemployment is to ease the burden of the economic insecurity that individuals experience due to unemployment. It causes a toll on their health, morals, and the welfare of individuals. And so unemployment was established many, many years ago, and it has kind of evolved from that time during the Great Depression, during that high unemployment rate. It is a joint state and federal program. It provides cash benefits to eligible workers. Each state administers its own program according to federal guidelines, and each state's unemployment system is different. They have different regulations, they have different rules, they have different state laws. So it is easier to get or less difficult to get unemployment in other states, and it can be very difficult to get unemployment in some states. The benefit amount is based on the first 4 of the last 5 quarters worked. So it goes back about a year and 3 months. The maximum benefit amount is $326 a week. You can receive unemployment for a total of 20 weeks for a total maximum benefit of $6,520. So in order to be eligible for unemployment, a claimant must be able, available, and actively seeking work. They must have access and exposure to the labor market. They must file weekly claims by telephone or on the department website. They must engage in work-seeking activity, which includes 2 work searches through the SC Works website, which is available through South Carolina Department of Employment and Workforce. You must wait 1 week after separation from employment to be eligible for benefits. and you have to be separated through no fault of your own, which is the big one. So individuals can be disqualified for unemployment benefits for several reasons. If they commit misconduct, which is basically behavior that is grossly outside what an employer has the right to expect, then they're completely disqualified. They can receive a minimum disqualification for a number of weeks if the department finds that they were disqualified for cause. So that disqualification is between 5 and 19 weeks. And basically you have to wait out those weeks before you can receive unemployment for the last weeks, equaling 20. And cause would be for repeated behavior that caused a problem for your employer. So if you were excessively tardy, things like that, you would usually see a disqualification for cause. Now, if an employee leaves work voluntarily, so they voluntarily quit work without good cause connected with the employment, then they are also completely disqualified. Now, good cause connected with the work was very fact specific and hearing officer specific, but usually would be something like a good example would be if you were being harassed at work or discriminated against, that would be cause to leave work and still receive unemployment benefits. So how does domestic violence cause job loss? Which I'm sure we can imagine. A victim is missing too much work because they're having to seek medical attention or they're in court. They're being harassed at work and that's causing a problem for the employer. So that's individual is terminated. It's causing too much drama at the place of employment, and that person is terminated. The victim fears for her safety on the job, his or her safety on the job, or en route to or from work, and quits for safety purposes. And I'm sure there are other scenarios that you guys may have seen. These are the ones that I've seen. So you can apply for unemployment either through the website or by phone. All ST Works offices have reopened after the pandemic. So there's also those physical places where you can go and now apply for unemployment benefits. It said the easiest way is really online. And you need the online access in order to manage your benefits now, because really there's no other way to meet those deadlines from unemployment unless you're constantly monitoring your personal portal with their website. So once you apply for unemployment benefits, someone from the department, a fact finder, will contact you and ask you a bunch of questions about the termination, about the separation from employment. They will then contact the employer, ask for their information regarding the separation for employment, and then make an initial determination. Now, I will say that unemployment is kind of like Social Security. The vast majority of applications are initially denied, and it's really, really important in these cases to appeal. Now, the appeal is due 10 days from the mailing date of that initial determination, which is why it's so important to have that online access and to have a reliable mailing address, which I know sometimes survivors of domestic violence have issues with. So online access can be really important for them. Now, if you're denied and you appeal that initial determination, you will go to your first level of appeals, which is with the appeal tribunal. And that's the lower authority appeals body. And you have a telephone hearing, which is basically a mini trial with a hearing officer from the Department of Employment and Workforce. This is the only opportunity that a claimant has to submit evidence and testimony regarding their separation from employment. This would be where, or their last opportunity to inform the department that they were involved in some sort of intimate partner violence, or they were in a abusive relationship that was causing issues with their employment. If you don't do it at this level, at that hearing, then you've lost your opportunity to put that argument forward. So once you have that hearing officer will make a decision. They'll send the decision out in the mail. It'll appear again on that portal, and you have 10 days from that date to appeal to the next level with the agency, which is called the appellate panel. Now that's a 3-judge panel that are also contained within the Department of Employment and Workforce. They review the record, they review your argument for your appeal, and they generally make a decision based on that. You can request an oral argument. I find that the best way in these situations to put forth your argument is in that appeal document, that letter that you send them saying that you want to appeal, and that is why. And attorney representation can be very, very helpful in these 2 appeal levels. So at the tribunal and at the appellate panel. At the tribunal, of course, because an attorney can make sure that all that evidence is on the record that needs to be in there. And then, of course, at the appellate panel, because that appeal needs to contain those legal arguments of why you should, in fact, receive unemployment benefits. Okay, so once the panel makes that decision, you have 30 days to appeal to the next level, which is the administrative law court. That's a much more complicated process, and you would definitely need the assistance of attorney in that situation, because that requires some briefing to be done, and it can be complicated for individuals who are not attorneys. So appealing timely from those decisions is of the utmost importance. Like I said, you only have 10 days from the mailing date on that letter of the initial determination to appeal. And it's the date on the letter, whether or not you received it within 10 days from that date. And those are hard deadlines. If something happens, or, if you never receive the letter, then that's something that you can fight. You would appeal late, and then have to go through another process through that appeals department to get a new hearing. And it can be done. However, it's just better to make sure that you're checking your portal and you're seeing those documents and you're making those appeals on time. Claimants should always also keep a copy of the appeal. Sometimes they get overlooked by the department, or, over the last couple of years, we've had some issues with mail, and they've, just never gotten to the department. So I always send them, if I'm filing the appeal, I send it several ways, by mail and by fax, just to make sure that I have proof that I sent it in. And of course, I make a copy of the envelope, and I keep that fax confirmation sheet. Okay, so within the unemployment system, there are specific protections for survivors of domestic violence. So a survivor of domestic violence is eligible for benefits if they left work or were discharged because of circumstances directly resulting from domestic abuse. They missed too many work days because they were seeking medical attention, or they had to be in court for orders of protection or family court matters, things like that. Okay, so directly resulting from domestic abuse, and either reasonably fears future domestic abuse at or en route to the workplace, needs to relocate to avoid future domestic abuse, or reasonably believes that leaving work is necessary for his or her safety or the safety of his or her family. And all of this, of course, comes out usually in that appeal hearing at that lower level. So if you have clients that you're working with that have had employment issues because of domestic violence, then in those initial fact-finding conversations with the Department of Employment and Workforce, and of course, your initial application, it asks for circumstances related to your separation. And those are the first times that you need to mention that you have had issues with your partner, that it was abusive, and that you were either discharged because of the partner's behavior or because you were afraid to go to the workplace or needed to relocate because of the previous behavior. Now, in order to get approved for unemployment benefits under this particular code, of course, the key to that is evidence. It's just like an order of protection. You need to provide information that ties the unemployment to the domestic abuse, which would include medical records, police reports, court records like orders of protection, family court documents if you have them. If you have a statement from a victim's advocate or a member of the clergy or a medical professional, that is also extremely helpful as well. A counselor, a therapist, although I find that they're sometimes not, they don't like to provide too much information in those types of statements. But
hey, Stephanie, I'm sorry to interrupt you. We had a question pop up, and it seems timely to what you're talking about. So
okay.
The question was, are these criteria an and or an or? In other words, does it need to be all of these or just one?
I guess we're talking about the previous slide.
I believe so.
Yeah, they're an or. Of these three circumstances, that unemployment or that the discharge or the voluntary quit is directly resulting from domestic abuse, and one of these three situations, either reasonably fears for future domestic abuse at or en route to the workplace, or needs to relocate, or reasonably believes that leaving work is necessary for the safety. Does that make sense? So in these hearings, it's also nice to note that whether we like it or not, hearsay is allowed. I'm sure you know from court appearances that hearsay is always or almost always prohibited in a court of law. However, evidence rules in unemployment hearings are much, much more relaxed, and hearsay is allowed, which means that the claimant can testify to threats made by a third party that affect the workplace in that hearing, or that would just be one example. Or a witness could testify to what they heard someone saying or something like that. It's a lower standard of proof than other civil, criminal, or unemployment benefits cases, basically because they're trying to make it as easy as possible for survivors to get benefits and to kind of rebuild their lives. So how can you guys help? So number one, I think the best thing was, encourage your clients to apply for unemployment benefits. And then, of course, identify the domestic abuse in those applications so that the department is on notice that that's what your argument is. Also, you can always help them get documentation together to provide to the department that proves that they are a survivor in the first place. Encourage survivors to appeal as quickly as possible to avoid missing deadlines, which is is really where most unemployment claims go south in the appeals process. And then they, of course, also have to file their weekly claims and do their work searches just to remain eligible. And then, of course, if you have someone who needs assistance with an unemployment claim, we're always available to assist. So I have some collateral employment issues just because sometimes when individuals leave work abruptly, they end up having other issues going on as well. And what I happen to see a lot is what's called wage claims, which is where your employer just doesn't pay you when they're supposed to. And when it comes to survivors of domestic violence, what you're usually seeing is they don't send you your final paycheck for one reason or another. So South Carolina has great protections for wages. We have what's called the South Carolina Payment of Wages Act. And of course, there's also federal laws that protect wages and of course, general contract law. Here in South Carolina, though, if an employer fails to remit your final paycheck, you can be entitled up to 3 times the amount of the paycheck plus attorney's fees and costs. And so that can really help a survivor of domestic violence, you know, monetarily, and have a little bit of extra cash. That is, of course, also something we do here at Legal Services. That's how I started out, which is also probably why I like to plug that as often as I can. And then let me check my time. Oh, I'm a little early. I'm sorry. I talk fast. So, of course, if you need to apply for services, our general intake line, if you have an unemployment situation or a client with an unemployment issue that is time sensitive, my phone is always open. You can call me directly or call Scott and he can forward you to me, and I'm happy to do an intake at any time. And I will see if there are any questions